mental status of the inmates of the prisons, and on the basis of he conducted his research. In addition to that, he visited 11 countries to examine the prison system in those countries and interacted with the prison officials. In addition to that, he visited Supreme Courts of that countries also. Sir has visited after clearing the advocates on record exam, which is conducted by the Apex Court Supreme Court, again with flying colors. Sir has been practicing in the Supreme Court and has experience of appearing before the Taluka Court, the lowest court of this land, to the Apex Court. I'm sure he is going to share this experience of his journey with you all. With this, I conclude the brief introduction of our chief guest. Thank you very much. And I'm sure you're all eager to listen to him. Thank you.
Thank you, sir, for this brief introduction. It is fortune of ours that we have a person who has achieved great heights in the field of law as a practitioner in the apex court of our land, having huge social network and still so pleasant and one among every one of us. Without taking much time, I now request our guest and eminent luminary, advocate on record, R.R. DESHPANDE sir, to guide our students on today's topic of pleading, proof and pleader, wherein pleader is a lawyer who pleads cases in challenges the claims of his opponent, and proof is the confirmation of the fact by the evidence that the judge needs to become satisfied that there is the preponderance of evidence in civil cases and the defense is guilty beyond reasonable doubt. In criminal cases, to know and equate ourselves more on the topic, I request Advocate R.R. DESHPANDE sir to guide our students.
Respected Principal Madam Dr. Baby Nathani, Professor Dr. Shetty RR, and other teaching staff, non-teaching staff, and my dear students. वकील खोटे बोलतात, काळ्याचं पांढरं करतात, पांढऱ्याचं काळं करतात. This is the very general allegations made against every lawyer. Why I am telling you at the earliest opportunity. You don't think that you have entered in the wrong profession or in the wrong course. Everybody from the society will try to discourage you, but be confident. I remember when I took admission in law college, here I was a student. I took admission here, and when I informed this fact to some of my friends from commerce side, science side, they said me, there is a proverb. I don't know now that proverb is prevailing or not, but by that time this proverb was prevailing very well. घोड्याचं नशीब फुटले की तो टांग्याला लागतो आणि विद्यार्थ्याचं नशीब फुटले की लॉला जातो. When all other doors are closed, all other windows are closed, the students used to come to LLB. It was their thinking, not apparent. But now, with full confidence, not in overconfidence, and on the basis of my experience in this field, I tell you, we are riding on the horse. We are riding on the horse, we are enjoying. So, anybody if discourages you, answer him by doing the best achievement in your life, in this career. I remember when I was a student, encouragement was very less, inspiring moments were very less, and the problem which I was also facing, because I learned, I was having Marathi medium instruction. In the so far primary education is concerned, I completed in municipal council primary school. Then I was a student of Marathi medium in Rajasthan High School. Then I was the commerce student. So everybody was saying you are made in commerce, that's why your English may be definitely weak. So when I entered actually to the LLB, for LLB course, that definitely, see, for first time I come across with the English medium instructions and the English medium learning. And on the contrary, I realized Professor Shetty Ada told you that I got gold medal in first year, but I want to share a secret with you. My English was very weak by that time, very weak, just like you. Probably some students might be facing that. But don't have any tension, don't have any botheration, don't have any fear or apprehension in your respective minds, please. I will tell you best humorous example. By the time when I was writing the answer to one of the question in law part, I remember just I was writing answer, I was trying my level very best to put the good English words in my answer. But at one point, I took a pause because I was not remembering the word, English word for Pithachigirini. I was reading, I think some, in thought one of the described the case is there, one floor was there. So I just wait for only half minute, and then I decided in my mind that I will straightway write down Pithachigirini. And I put an inverted comma and write down a Pithachigirini. So don't have, if now otherwise also, at present also when I am arguing before the Supreme Court, I use the word, you know Veda in the rural area, Veda, the beacon which we used to, for the purpose of cutting the sugar cane, Veda, Bhakti, in all, right now also, all the senior advocates also, who can't find the substitute or the English word for Veda, we simply used to say Veda, and if the judge asked them, we used to describe it, what is meant by this. So actually they don't have any tension. So what qualities are you required to become a successful lawyer? Because here it is told to me that I must share all these ideas. When it was instructed to me that I don't want to praise myself here by taking this opportunity or whatever is about mine, R.R. Shetty has told. R has given introduction, another R has to repeat it. So I will that. So what qualities we require here, I will tell you. The first most important quality, you must have crystal common sense. My friends, I will tell you, law is nothing but crystal common sense. In one line, may I say you, 2% knowledge of law and 98% common sense is required to become a successful lawyer. If your common sense is crystal, it is clear. If you can grasp, you can interpret the circumstance, if you can interpret the word, if you can interpret the provision, it is sufficient for you to become the great lawyer, successful lawyer. Particularly, the second quality which you want to become successful lawyer, you must have the knowledge of Marathi as well as English also. I am not expecting the expert English for fluency over the English, but at least you must have the basic stock of the English word so as to at least express your arguments or the basic contents of your argument the judge must come to know. Otherwise, what you are arguing, the judge should not say after completion of your argument of 30 minutes, I am sorry, I could not understand your argument, unfortunately. So this thing should not happen. So that's why here you must practice particularly in the district court and the taluka courts and in the high courts. So far Supreme Court is concerned, Marathi is not allowed there. Even a document which is in Marathi is not accepted. We have to find the translated copy of that document in the Supreme Court. But in High Court, Marathi is allowed. Marathi document is allowed, document is not allowed. So you Marathi is required so far practice in district court is concerned. I don't know how many students are here who are studying in the final year of law, and if they have decided to start practice in the district court here or somewhere else, then they must have the Marathi knowledge for this purpose. Majority matters are from the rural areas. The language in our, particularly in Latur district, in rural areas altogether different. In urban area, it is altogether different. I will share with you very interesting word. In Latur district, entire Latur district, wife is called as a cutler. Do you know this fact? But in court, when I started practice here in Latur district court, and when I was asking the question in the cross examination, so I was constrained, I was compelled to ask the witness, where do your cutler resides? And then he was in a position to answer me, my wife resides somewhere else. Now, do you know, the rural people don't know east, west, north, south. They don't know. And for your information, when I took admission to the Bachelor of Journalism and Media Science for first time in life, I came to know that what is meant by news. Do you know the long form of the news? N stand for north, E for east, W for west and south, S for south. So whatever information is coming from all these directions required news. So far cross-examination is concerned, because see here, directions are very important. Whenever there is a immovable property dispute, we have to naturally ask where it is situated, what is the location of that property, how you will describe, where is your property, where is my property. So for that purpose, do you know that Dakshin means Raksha Kadai, or rural people say Raksha Kadai. North means Ganga Kadai, from north side, Varla Kadai, Khalla Kadai. These are the directions. So we must know I came across with one of the Kokani case, wherein husband is called a Chedu. So in cross-examination, if I want to put a question to the wife in maintenance case, I have to ask her what your Chedu do. So it is very interesting. So just and by the same time, I want to suggest you that your knowledge must be full-fledged. See here, you must have knowledge from almost all the fields, and you must have the attitude of the research to look forward towards this, each and every word from the law in a different sense, in a different view, in a different angle, and that is important to become a successful lawyer. I will share with you a very interesting example. When I was speaking here to the students, I was giving that much example, and I just told the man that I am feeling just like this home return. After so many years, I am again on the dais, and some students are before me, but probably this time I will not get the honor for the salary, and I don't expect. But by that time, I was habituated to receive it. So I will share a very interesting thing. Actually, it is a joke, but you will get a very best sense of interpretation. What has happened? Husband in Marathi, I will share with this way, or in English. Which one will you prefer? Sorry? मराठी. नवऱ्याने बायकोला सांगितलं की तू अमुक एका किराणा दुकानामध्ये जा आणि तिथून गहू, ज्वारी, बाजरी वगैरे वगैरे घेऊन ये. माझं तिथं खातं आहे, त्याला सांग माझ्या खात्यावर द्यायला मी पैसे देऊन टाकतो. बायको तिथे गेली, तिनं गहू, ज्वारी, बाजरी घेतली, तर त्याच्याशिवाय तिनं 3 गोष्टी जास्त घेतल्या. एक घेतली पॉन्ड्सची पावडर. As usual, it is not natural on the part of time. Second thing was the lipstick, and third one was the hat. So when after 1 month, 1 महिन्यानंतर जेव्हा त्या दुकानदाराचा नोकर त्या मालकाकडे आला, नवऱ्याकडे आला आणि त्याने बिल दिलं, त्यावेळेस नवऱ्याने ते that servant went to the wife and requested, pay me the bill, because your husband has declined to pay this, pay me the bill. She said, I am sorry, माझं तुमच्या दुकानामध्ये खातं नाहीये, तुम्ही मला कधी उधारीवर देण्याचं कारण नाहीये, माझं तुमच्यापेक्षा ओळखही नाहीये, माझ्या नवऱ्याने मला सांगितलं ते घेऊन आले. Then again that fellow बिचारा परत नवऱ्याकडे गेला, त्यांनी सांगितलं बायको तुमची असं म्हणते, तुम्ही द्या. तो म्हणाला, I am sorry, I can't. The question was this. Husband said, मी माझ्या बायकोला हे आणण्यासाठी ऑथोराइज केलेलं नव्हतं. तिनं ते तिच्या मर्जीनं आणलं, तिनं ते maybe people or big, we are pet. This is the duty of the lawyer to argue the case, irrespective what client is getting. Advocate has brought something else other than these 3 things, and that's why lawyer of wife was so intelligent, just like you. So he started to argue that husband's word is very strong. 3 alphabets are there. But here, when you become lawyer, you have to concentrate on EPC, which we think is a very otherwise word which can be ignored. I argued here in the division because it was my contention being कोंबडी उडते म्हणजे ती पक्षीच होते. ती किती उडते याला महत्व नाही. जागेवरून ती उडली, एक फूट जरी उडली असेल तर ती पक्षी होते. But other side was saying no. The issue was that the municipal corporation Latur had issued notices to some of the clients that you can't cut, तुम्ही कोंबडी तर कट करू शकत नाही आणि तुम्ही चिकन सेल करू शकत नाही सिटी मध्ये because it amounts to slaughtering of the animal. So I was trying to convince it is not slaughtering of the animals. कारण animals मध्ये ती येत नाही, ती bird आहे आणि birdला मारायला मला परमिशनची गरज नाही. I have a pleasure to share with you that I succeed and still those shops are working. Your judgment in that case so far, वगैरह is concerned, who is right? Husband or wife? Wife is right. I'm sorry. Because it seems that ladies are saying wife and gents are saying husband. It is but natural, I can understand. But the judgment is basic here. I interpret the word EPC, that the golden rule of principal man which is introduced in the law of interpretation is this. While interpreting a particular word from the sentence or from the group of the words, you have to interpret the word taking into consideration the words which are accompanied to it. That is the rule of interpretation. So in Gahu Jwari Padri, what is anticipated? Harbarachi dal, turichi dal, not hat, not lipstick, not powder, because here the category is different. So intention on the part of husband to authorize with the use of the word vagera was something different, and which was ought to be towards the interpretation of each and every word. Now the next thing, see here, the most important thing which I want to share with you today, the skill of advocacy. When you are before the court, you must be good-minded. I did PhD in criminology, just introduced. I had been to 6 prisons. I stayed in 6 prisons. But I'm sorry, not an accuser. As a research student, I had been to the jail. So I stayed there. I have taken interviews of 60 lifers. And I have diagnosed my conclusion was this. You can resist all things in the world except one. That is your own temperament. You used to become victim of your own temperament and then you become criminal. If you don't want to become criminal in life or if you don't want to commit any crime in the life, the best victory in life is to conquer self. दुसऱ्यावर विजय मिळवणं खूप सोपं आहे, स्वतःवर विजय मिळवणं फार अवघड आहे. सो स्वतःच्या रागावर कंट्रोल करा. मला नाही वाटत तुमच्यापैकी कोणी रागीट असतील म्हणून, पण जर असतील तर त्यांनी कृपया हा सल्ला नोट करायला हरकत नाही. कारण जेणेकरून जेव्हा तुम्ही उद्या लॉयर प्रॅक्टिस कराल त्यावेळेस तुम्हाला ते खूप हेल्पफुल असेल. हाऊ आय विल एक्सप्लेन यू मस्ट बी गुड माइंडेड. द जज विल पुट यू lot of queries. Most of them even may be relevant, but you cannot say so because he is judge, he is in the chair. You have to maintain this protocol. You have to respect him. So there is a proverb in English which you must, if it is possible on the part of you to note down in the notebook, you please note it down. When you will become lawyer, this will be very helpful to you. There is a proverb. If you want to cross the river, you should not criticize the mother of crocodile. Otherwise, there will not be safe journey of crossing the river, and that's why you say here, when you are arguing before the judge, before the court, you must have the cool mind. Whatever questions you want to ask, you must convince him. And another skill I will give you, if you are not able to convince, confuse him. You will be benefited. At least otherwise you will not lose your matter. At least you must have either of this thing. If you are able to convince, try to convince the last moment. If it seems that he is not responding to you, then definitely you can start to confuse him. At least the case will become balancing. You know, so far, pleading and proof is concerned. Actually, when sir told me, when asked me that what subject you will prefer, Just for the sake of name title, I have given this, but actually I want to share with you all the ideas so far advocacy is concerned. You know what is required to be pleaded and what is not required to be pleaded. In my personal experience, I will share with you because I feel myself so lucky that I argued the lowest post in the judiciary which I must say, Nayab Tasildar. You know, CRPC 107, 108, 110, these matters are concerned. The accused used to be produced before Nayab Tasildar and that bail we have to. Even I argued before the Nayab Tasildar on one hand, on the other hand I argued before the Chief Justice of India. So on the basis of my these experience of all these arguments, I would like to try with you. Your arguments means firstly we have to face your entire case in the pleadings. Because whatever you plead, you can prove. Whatever you prove, then you can put your argument on the basis of that proof. If there is failure in laying down the foundation in the pleading, it is not possible and it is not admissible even to prove the fact which is not pleaded. It is not allowed. So you must plead first, then you must prove it, and then you must argue so as to convince for all this pleading and prove to the judge. Very interesting thing is this. See here, the rule of pleading is applicable only for civil law. So far criminal matters are concerned, there is no rule of pleading. You need not plead also. So far the pleading in the appeal memo and other things are concerned, those are very difficult pleading based on the factual aspect and not on the law. In civil, we have to plead each and everything minutely with the full detailed study. See here, those who want to become the civil law practitioner, they must be very confident. They must go in detail in respect of all the civil provisions. See here, in one line humorously I may tell you, when I started practice, I started to see the civil practitioners are vegetarian and criminal practitioners are non-vegetarian. I don't know how many amounts you want to become vegetarian lawyer and non-vegetarian lawyer, so far matters are concerned. If you want to become vegetarian or the civil practitioner, then you are expected to take a lot of efforts. Your study must be very hard. And with confidence I may tell you, if you are having a good legal knowledge, legal study, if your case is correct and if your common sense is very crystal clear, then definitely, in my opinion, the first judgment of civil matter is always used to take place on the table of the lawyer, and second judgment in the court. As soon as you see all the documents and the case, if you what you heard from your client, definitely your confidence level, if it is there, definitely it will be high, and you can decide. You can surely say to the client that you will win, don't worry, I will get it. But so far criminal matter is concerned, your knowledge ought to be very, very sharp. You cannot prepare in advance for the criminal matter because suddenly the witness will be examined before you and immediately you have to put the cross-examination. As soon as chief is over, you must start the cross-examination to the witness. And it is very interesting to note here what to put in cross-examination and what not to put in cross-examination is very material. If you put a question, with humorous I must say you, I will share with you. If you are disputing a marriage with the lady and if you put a question to her that how many kids you are having, you lost. You lost. Because here it is implicit. You should not put a such type of question which is wiping out your case. So you ought to be very cautious when putting the questions in the cross-examination. That's why so far the criminal matters are concerned, error is not allowed. Mistake is not allowed because there is no provision of amendment in CRPC so far my knowledge and belief is concerned. At the most there can be the clerical correction, arithmetical corrections are allowed in CRPC, but amendment is not allowed. So you cannot say, no, I'm sorry, this question was wrong, I take it back and I will ask another question in the cross-examination. Whatever you asked, it is recorded. So I will tell you with the help of another example that see here doctors and lawyers are having some similarities and some dissimilarities. Both of them are not allowed to commit mistake. If you want to become the criminal lawyer, Criminal lawyer means a criminal law practitioner. If you want to do practice on the criminal side, mistakes are not allowed, because your mistake may cause heavy damage to your client and even may cause heavy damage to your career also. I will give you the Marathi explanation. डॉक्टर्स आणि वकिलांनी त्यातल्या क्रिमिनल साईडला जे प्रॅक्टिस करतात त्यांना कुठलीही चूक अलाउड नाही. वकिलामध्ये आणि डॉक्टरमध्ये काही सिमिलॅरिटीज आहेत, काही डिसिमिलॅरिटीज आहेत. पहिली डिसिमिलॅरिटी अशी आहे, ते पांढरे कोट घालतात, आपण काळे कोट घालतो, बरोबर आहे. त्यांच्याकडे पण इंजेक्शन आहे, आपल्याकडे पण आहे इंजेक्शन. स्पेसिफिक रेजिमॅक्ट मध्ये इंजेक्शनची रेमेडी आहे, त्यांच्याकडे पण आहे, आपल्याकडे पण आहे. तर दोघांमध्ये सगळ्यात महत्वाची सिमिलॅरिटी अशी आहे की दोघांनी चूक करून जमत नाही. त्याचं कारण असं सांगितलं जातं, डॉक्टर कडून जर चूक झाली तर त्याला जमिनीपेक्षा 5 फूट खाली काढलं जातं, वकिलाकडून झाली तर 5 फूट वर ओढलं जातं. He will be hanged in death. So there should not be any mistake at the hands of particularly criminal lawyer. So I was telling you about this. Friends, here I will suggest you. Now, when there always used to be a gathering of the friends and a group of the friends, or nobody preferred to remain lonely in the college campus. So everybody at least might have 1 friend, 2 friend, 3 friend. So just have the habit to assess your friend. Just only don't have the gossiping and the bed and pani puri and chai only. You just assess your friend, who is your close friend. Look towards him. Look towards his personality. Assess him. Because here it is very good habit on the part of a person who wants to become the lawyer that you must assess the personality first. If you put a question to me, चांगला वकील कुणाला म्हणायचं, तर माझं उत्तर असं असेल, त्याला लॉ कळतो तो नाही, ज्याला जज कळतो तो. लॉचं नॉलेज तर खूप जणांकडे आहे, पण त्या जजला काय हवंय आणि तुमचं काम आहे, यू आर पेड फॉर दॅट. त्या जजला जे पाहिजे ते द्या ना. माझं नॉलेज खूप आहे दाखवण्याच्या प्रयत्नामध्ये देयर विल बी लॉस ऑन द पार्ट ऑफ यू ॲज वेल ॲज युअर क्लायंट. सो व्हॉट ही लाइक्स जस्ट गिव्ह इट, फीड हिम लाइक दॅट, and it will work out definitely, it will sort out definitely. And so that's why my suggestion would be this. तुम्हाला ना एक असं पर्सनॅलिटी असेसमेंट सवय असावी, ती एक हॅबिट असावी. तुम्ही प्रॅक्टिस कशी कराल हे जर मला विचारलं तुम्ही, तर देयर आर फ्यू व्हेरी गुड एक्झाम्पल्स. आय विल टेल यू. माय फर्स्ट सेंटेन्स ऑफ द स्पीच वॉज दॅट वकील खोटे बोलतात. आय मस्ट कन्फेस, so far our constitution is concerned, our status is as a legal advisor and not as moral advisor. If you are doing the practice on the criminal side and if your client is making confession before you that yes, what you said, me marlay kara, what you are expected to direct him, whether you will direct him, you court samor sang me marlay manan, he will not stay in your office for a single minute or so. He will immediately say, this lawyer is very dangerous, he will send me to prison, I don't want this lawyer. So you are expected being a legal advisor because you don't know whether he has committed the crime or not. You don't know whether he is compelled to confess before you or not. You don't know what is really happened because that is not none of your job. It is the job of the judge to tell the truth. The judge will tell the truth. Both of the advocates will try to place the truth before the court, will try to put forth their respective cases before the court, and judge will decide the crime. That's why see here, several questions are put to me particularly that when the client confesses before you in your cabin, what is your obligation? I repeat, my obligation is this. I am a lawyer. I will stay as a lawyer. I will advise him as a lawyer. I will receive my fees as a lawyer, and I will do all things as a lawyer, not as moral advisor. Because see here, lawyer cannot be sadhu sant at any cost. If he is becoming sadhu sant, he will fail. Don't go for criminal side. Its civil will be better. So very humorously I will tell you, it is a great humorous sentence in the world that पक्षकाराला न्याय मिळवून देण्यासाठी वकील काहीही करू शकतात, वेळ पडलीच तर खरं सुद्धा बोलतील. sometimes we have to tell truth also. If my client wants justice by telling this, if I succeed by telling this, I must disclose the truth also. That's why see here, the skill of advocacy is in all these things, that how you put your case, how you present your case. That's why I will advise all of you. I am sorry if you are not participating in debate competition, good court competition, you are committing a very grave mistake. You will punish, you will be definitely will suffer for that in your entire whole career. You must have talkative nature. You know, everybody says, खोटा बोल पर डायरेक्ट बोल. Maybe ultimately, I am not saying so this is acceptable phenomena, but you must have skill to put forth your case. You don't know is it false or true, but you must have that skill with you, that you must put forth your case very strongly. Just with a remote devotion must be to that extent. I will tell you, rivers may dry, heavens may fall. I don't know, but my client must get justice. नद्या कोरड्या पडल्या हरकत नाही, स्वर्ग पडला हरकत नाही, माझा क्लायंटला नाही मिळायला पाहिजे. I don't know anything else. And if this is the devotion on the part of us, I will tell you, you will be able to earn at least 20 lakh rupees per day. Now, for appearance, the advocates are charging in the Supreme Court 20 lakhs, 25 lakhs. And one of the very interesting thing in this profession is that Madam, I think after retirement she will definitely start the practice, because there is no age limit for the practice is concerned. So we are in this beneficial. So all others can do the job till 58 or the 60 as the case, maybe not more than that, because the law presumes that they are tired. But it is a complete reverse thing in this profession. That when now I am running 59, I am getting a lot of matters. Actually, it is retired. I always used to tell my wife that I am retired. But unfortunately, I am getting a lot of work here now, because the reputation or my devotion has achieved a destination, a particular destination, and that I am going to be benefiting. So what I was telling to you, just with the help of one example I will give you. You are very lucky if you are entering this profession. If you are after completion of the LLB joining judiciary, it is also a good thing, no, not problem. But don't join as a clerk or somewhere on the subsidiary post. The practice will be very better for that. Mr. Ram Jethmalan, you might have heard about him. So I got an opportunity to hear his argument at the Supreme Court on a lot of occasions. So when he was arguing at the age of, now he is no more, I think he died before 1 year. So I think it is an incident of 3-4 years back, when Mr. Ram Jethmalan was arguing before Chief Justice Thakur and 2 other judges in court number 1 of the matter. His age was 93 years. He argued the matter very well before the Supreme Court, criminal matter. He was a criminologist, you know very well. So when he just took a pause in argument, Mr. Thakur suddenly, Chief Justice of India, put a question to him. That Mr. Jethmalani, let me know when you are going to stop the practice. Because at the age of 93, he was so practicing very well. So the Mr. Thakur was interested to know. My dear students, his answer was so nice. After all, he was Jethmalani. His answer was so nice. We were actually thinking to clap in the court hall, but being the requirement, the protocol was there. That's why we could not do that much. But he answered very well in English and in Marathi. I will tell you. He asked a question to Justice Thakur with some courage, that let me know why my lords are interested to know that when I am going to die. मला हे कळू द्या की तुम्ही हे का विचारता की मी कधी मरणार आहे. What is meant by this? He said, I will argue till my death, and I will not so easily allow you to live. Saraswati नाही म्हणणार तुम्हाला. And so just see here, you can enjoy this practice for the several years till the moment of death. Everybody has to die. But while working, just like see here the example of Amitabh Bachchan, is there any need on the part of him to earn money right now at this age? But still he is working in lot of advertisements and he is getting the same. So just you are investing for your entire future life in this profession. Otherwise, in other profession or other jobs, your right will be curtailed after 58, after 60. So this is nothing but the investments. Here what happens, very humorously I always used to tell so far one person, any person in the staff retires. So what happens definitely, particularly just few months before one of the lecturer, my friend lecturer from Science College retired, Mr. Kishore Panse. So I was also invited to deliver some, some thinkings to express my thoughts on that. So I said, what happens after retirement? So far, I looked towards Mrs. Panse and said, till this moment you are getting half time of your husband but full salary. But now you will get full husband time but will get half salary. Because there will be the pension now here. So see, yes, some loss is there, some benefit is there, some loss is there, but so far lawyers are concerned, they can enjoy continuously till last moment. So I was just sharing with you all these ideas. Particularly, you might not be taught actually in the classes, but with the help of, for example, some ideas I want to make clear on the part of you. What are those ideas here? In criminal law, if you want to go for the criminal side practice, you know, it is very interesting to know that exactly what is meant by intention, what is meant by common intention, what is meant by accident, what is meant by negligence. So all these things are very important so far criminal practice is concerned. So if you are already well acquainted with these all things, it is better. But if you are not acquainted, then you have to concentrate on that if you want to go on the criminal side. I remember when I was the lecturer here, with the help of one of the very interesting numerous example, I was trying to tell that. So all these examples are not from the books. I have read somewhere, some of the examples are prepared by myself when I was having the leisure time. So what is happening in one case in Marathi, that will be better for you on the part of you to understand it. एक नवरा बायको एका झाडाखाली गप्पा मारत बसलेले होते. सडनली एक पक्षी त्या झाडावर बसलेला बायकोने बघितला आणि त्या पक्षाचं वैशिष्ट्य असं होतं की तो पक्षी मारून खाण्याचं तिथे जास्त प्रश्न होता. तो पक्षी टेस्टी होता. त्याच्यामुळे बायकोने लगेच रिक्वेस्ट केली नवऱ्याला की काही करा, तो पक्षी मारावा, खायचा आहे. त्याच्याजवळ छोटीशी रिव्हॉल्वर होती, छोटीशी बंदूक होती. तिला खूपच इन्सिस्ट केल्यानंतर बायकोनं त्या नवऱ्याने ती गोळी झाडावर मारली आणि गोळी त्या पक्षाला लागायचं की त्याच्या पाठीमागच्या फांदीवर एक व्यक्ती बसलेला होता. ही सस्टेन गन इंजुरी, बुलेट इंजुरी, and he collapsed from the tree and he died. So what is this? What you will tell to this? काय आहे? Sorry. Accident? Negligence. You are correct. This amounts to negligence. Punishable under what section? 304A. Am I right? Causing death by negligence. Because while shooting a bird, you must take care that it should not cause injury to somebody else. So injury is there, definitely it is a causing death by negligence. Then what has happened? ते खाली पडलेलं बघितलं की नवरा बायको दोघे घाबरून गेले आणि ते पळत सुटले. नवऱ्याच्या हातामध्ये ती छोटीशी गन तशीच होती. पळता पळता एकमेकाच्या पायात पाय अडकला आणि ते तिघं दाबलं गेलं आणि ती गोळी बायकोला लागली. तिथे बायको भरून पडली. What is this? Exactly, you are correct. Oh, we said that you are very intelligent really. You can come to the Supreme Court. Definitely you can come. Madam has expressed her view in respect of expectation from mine. So I will tell you, but let me pause for that example. I will continue that example later on. What are the expectations of the principal man? That you should get internship in High Court and Supreme Court. Am I right? If anybody is interested, definitely my promise is with him. He can contact me. I will give my number if you say right now, or I will give it with ma'am. Whenever you want internship in either High Court or the Supreme Court, as of right, you can come. It is your right. It will be my privilege. But just madam's expectations are there, but my expectations are something more than you. Because I know that when I do practice on the criminal side, and particularly I am the doctor in criminology, short dream is crime. So I think big dream with respect of all of you, don't come for only internship in the Supreme Court. Try to become viewer in the Supreme Court just like me. And for that purpose, whatever assistance you want, whatever help you want, whatever facilities you want, including the facility of the staying daily, we are able to provide you. So try to become a lawyer. Just first to become a lawyer, what formalities you have to complete. Just making these all things for the purpose of inspiration on the part of you. You should not feel at the cost of reputation. I entered in wrong profession, I entered in wrong course. Don't say, because there are several persons who say so, but you should not have the botheration of this. Here, as soon as you enroll yourself as an advocate with the Bar Council of Maharashtra and Goa, you have to complete 4 years practice. Thereafter, you have to join with a lawyer who has completed 10 years practice in Supreme Court as a lawyer. So I have completed 10 years. So you can join as of right training with me for 1 year. Thereafter, after 1 year after completion of the training, you have to appear for one of the examination, which consists 4 papers of 100 marks each. There is no viva or the oral, only written examination is there, and the screening committee of the Supreme Court used to conduct that examination every year in the month of June. So as soon as you complete, you pass out that examination, you are eligible and you are entitled to do practice in the Supreme Court. Now see here, to do practice is a different thing, and to argue the matter in the Supreme Court is a different thing so far Supreme Court rules are concerned. Only advocate on record can file the Vakalatnama. Only advocate on record can file the case in the Supreme Court. None else is allowed. But if suppose ma'am tomorrow wants to argue the matter in being lawyer before the Supreme Court, now I have to authorize her. You can appear on my behalf. I am the advocate on record. I am responsible for this. You can argue on my behalf. And subject to my authorization, she can argue. She can appear and argue the matter. So if you want to file the matter, if you want to become the advocate on record, then you must pass out this examination. I remember in 2008, somewhat we 900 advocates appeared for that examination, and we 32 only cleared. Only 2 advocates from Maharashtra were there who cleared this examination. So my invitation to all of you will be this. You come for the internship, you are welcome, because it is but natural. Now we have to confine ourselves for internship, not more than that. But just I said I don't know whether these people will prefer to call me again or not. So I am getting this opportunity, enjoying this opportunity. Because if they like, they will re-invite, otherwise I don't know. So this is an opportunity on the part of me to share for the long vision also. And that's why I'm sharing with this view. So I will continue now the example. So where were we? White died. It is a clear case of accident. Am I right? It's a case of accident. Then what is happened? The brother of wife was looking all these things. There was some misunderstanding on the part of brother of wife. That is brother-in-law of that husband. So there was some misunderstanding, and he thought, now husband has killed my sister. And he immediately took a stone, big stone, and put it on the head of that husband. And he died. What is this? Sorry? Yes, murder. This is clear that murder with knowledge, with intention, with a very thing. So see here, in one and the same case, we are looking 3 deaths in 3 angles, in 3 different sections. Do you know, Indian Contract Act and Indian Penal Code is called the master laws. तुम्ही कुठलाही प्रकारचा करार करा, इंडियन कॉन्ट्रॅक्ट ऍक्ट मध्ये त्याला उत्तर नाही असं नाही. कुठलं ना कुठलं तरी सेक्शन त्याला कव्हर करायलाच. यू नो इंडियन पेनल कोड, कुठलाही गुन्हा करा, आता काय असं झालेलं नाही की सॉरी आयपीसीचं कुठलं सेक्शन लागत नाही म्हणून आम्ही तुम्हाला प्रॉसिक्यूट करत नाही, असं होत नाही. डू यू नो सेक्शन 511? It is very interesting. See here, what is the section 511? Attempt to commit offense is offense. मी समजा माझा विचार झाला की काय घरामध्ये चोरी करायची आहे, मी सगळी तयारी केली आहे, कंपाऊंड वर चढलोय आणि परत लक्षात आले की मध्ये 2-3 मोठे कुत्रे आहेत म्हणून मी कॅन्सल केला आणि वापस आलो. It will not definitely amount to theft, but it will amount 379 read with 511. This is nothing but an attempt. So That's why here very interesting cases you will find. I remember one of the cases another here, the lawyer's intelligence, lawyer's excellence is very highly anticipated for each and every facts of the case. You know 323, it is very good, the first section. But very interesting case happened under section 323. Again, I am referring all these examples just to create a research look towards the matter or towards the facts of the case. What is happened? I think this side will be here with me for this example. What is this example? In Marathi, may I tell you? एक मुलगी तिचं घर असं एका डाव्या बाजूला आणि एका मुलाचं घर उजव्या बाजूला. ती मुलगी दररोज पायऱ्यांनी वर चढायची आणि उतरायची. तिच्या घरी जायची फर्स्ट फ्लोअरला आणि खाली यायची. या मुलाला एक सवय लागली होती. तो त्याच्या टेरेसवर यायचा आणि ती पायऱ्या चढताना आणि उतरताना कंटिन्यू बघत राहायचा. This program was going non-stop, continuously. He was knowing की किती वाजता खाली उतरते, किती वाजता वर जाते, म्हणजे कॉलेजला कधी जाते, वापस कधी येते, सगळं. He was continuously watching. It was, it caused irritation on one day on the part of that lady. Naturally it is. कशासाठी ना? Why for? You are disturbing my privacy. So that lady filed a complaint with the police station, and the question arose whether 323 can be applied here or not, because there is no calling of the heart. He didn't come near to her at any time. He didn't any. The police registered the crime under section 323. Matter went to the court. The court also was considering very seriously what to do in this matter. So that's why I said the IPC is the master law. It is not happened yet that there is no answer to any of the criminal case. So in this case, what is your expectation? What might have been done by the court? Is convicted or acquitted? Students from Patna? Sorry? In this case, what it happened, the argument was very excellent, the argument was very nice. See there, section 323 does not consist a word that is physical assault. Absolutely, it does not consist. It is a voluntarily causing hurt. Hurt may be mental, and he was punished naturally. It was with minor punishment just so as to teach him the lesson only, and so the minor punishment was given. I think with this you are getting bored. I will stop here. So I hope if some questions are there from your side, I will welcome it now.
Sir, can I ask one question?
Please.
There is always this international level conventions and many things are there which are in favor of abolition of capital punishment. As you've done chronology, you're expert in that. You've come across so many cases in Supreme Court. I would like to share your experience with our students, as I'm also teaching human rights, how we can relate it, whether abolition of capital punishment is acceptable in India or shall we continue with that?
Very good. Actually, it is the most favorite subject on the part of mine because my thesis consists as a separate chapter on this about abolition of the capital punishment. I will give you a best example. When I was facing Viva, and so far capital punishment is concerned, I have opposed it because you know the philosophy of Mahatma Gandhi, hate the sea. So nobody wants to become criminal. The circumstances makes him so. Circumstances compels him so. If there is no food in the house, naturally the better person will commit the theft of food. So he should not be punished for that. So I remember when I was facing the Viva, I have opposed to this capital punishment. One of the examiner, a referee, put a question to me. He said to me, Mr. DESHPANDE, you want to be a doctor, saying that capital punishment. Imagine Abu Salem by that time, because when I was facing the Viva, Abu Salem was arrested just now. And so he put a question to me that how you will treat Abu Salem when just like terrorist is brought before you, you want to become doctor, you want to treat him without giving him the capital punishment, without killing him, you prescribe your medicines. The question was very really intelligent question. Just I took a pause and I said that If you want treatment or the prescription from my side, from Abu Salem, you are expected to tell me the history of patient. Because unless I know the history of the patient, because I know what compelled Mr. Abu Salem to come in the criminal field. I don't think Abu Salem went to the birth, he was criminal. I don't accept this. I don't know whether his parents were also criminals. His mother, father were criminal. So unless and until I know the history of the patient, I am not in a position to prescribe. But still then I say, whatever history I know, on the basis of that I will prescribe. And I say that he was a good friend of one of the terrorists who was the known terrorist, who was the, I must say, not popular, but very cruel terrorist in India and Pakistan. And he came into his company and he was constrained to come in this field. And if it is so, he is the good patient for information. And I said that doctor may not be the good doctor, so we can treat him, we are having scope to treat him. And so far answer to your query is concerned, see here, in this sentence itself answer is there. If you are able to treat him, you must treat him. Capital punishment is such type of risky punishment, very, actually it has to be used very exceptionally and rarely. Actually, it deserves to be abolished. But so far the Pakistan movements are concerned and Pakistan terrorists are concerned, I am not in a position to give you the concrete conclusion, because here, if a person just like I think Kasab, if he commits, if he kills 100 people, then I don't say that. Still, we will maintain him at our cost by our imposing cost on the general public. Because when I stayed in the prison, that prisoner was telling me, when I said you must give this facility, he said each individual expense to such extent on the part of the government, they are the criminals. How much more can we incur expenses for them? It is alright, I think, not more than this is expected and anticipated. So I think if you are getting 100, you deserve the capital. So my suggestion was that, my conclusion was that there must be a specific criteria prescribed in law. That is the case of triple murder, more than 3 murders, or if suppose such type of cruel, just like I know even of the case, you might have heard about Tandoori case from Delhi. One of the lady was broken in the pieces and those were kept in tandoori, roti maker that in the fire. So those are the facts that definitely these people don't deserve any sympathy in the law and they should be hanged. But generally, so far single murder is concerned, even the repeters are also concerned. It will not be better, because here we cannot exactly, adultery, rape, all these things are very secret acts. We don't know actually what is happened and what is not happened, we don't know. So grossly, we cannot say that law is 100% perfect. Law is very ideal. Even in thought, assault, battery, हात उगारलं तर असॉल्ट आहे, लागला तर बॅटरी आहे, एखाद्याकडे तो अजून तुमकलं तर असॉल्ट आहे, त्याच्या अंगावर तुमकलं तर बॅटरी आहे. म्हणजे बघा ना, लॉ किती छोट्या छोट्या गोष्टीला कव्हर करतो. म्हणजे लॉ खूप आयडियल आहे, म्हणजे इम्प्लिमेंट करणारी जी मंडळी आहे, जस्ट लाईक इन केस ऑफ पोलीस, इन्व्हेस्टिगेट, लाईन ऑफ इन्व्हेस्टिगेशन, faults in the investigation. So with the on the basis of this, I can say we are not really a perfect good system for the investigation purpose. Just like in London, there is a very specific good system. Ratio of the conviction is more than 90% there. Right here, it is only 12%, 13%, 18%. So from that we can assess that system is having some to extent fault. So finally, I conclude with this my answer, that capital punishment ought to be used in exceptional and very rare cases, because once he is hanged, you cannot take him back. When you cannot give birth to the human being, you cannot take his life also. If you are able to give, then only you can. Otherwise, law is not able to give.
Many times what happens is, for the even for the young offenders, the first offense, I teach criminology, sir. So many interested in that. Many times it is hard to convince to the students that how the punishments or the reformations are justified, and especially with reference to the victims, because they are suffering at no cost. But even the criminals who are young offenders or first offenders, but still they get the facilities and good treatment in the prisons. So how do we justify that?
See, so far punishment or the reformation of the culprit is concerned, of the offender is concerned, no doubt. Myself have studied Python open air prison. I want to tell you there are no barricades and no rooms etc. in the prison, Python prison. It is open prison, just big sheds are there and they can enjoy. Even when I went to the bus stand, I found several prisoners there in the prescribed address. They were doing Hamali work or the labor work because they are allowed to do this. 3,000 acres land, agricultural land, the prisoners used to cultivate in Python prison. So a lot of facilities are provided to prisoners inside the prison. Now the same thing. Again, I remember my Viva because all these questions were put to me being I was doing the PhD in criminology. I had suggested in my thesis that you should provide the polytechnic colleges, ITA colleges, or the branches of the same in the big prisons. Because whosoever young persons are there, young prisoners are there, they should learn something, and when they will be released, they should get some job outside the prison. So one of the questions, exactly just like it was put to me, that you are taking care of regular admission in polytechnic college in prison if your idea is implemented. So I suggested that definitely I appreciate your query, but my answer is this. See here, their scope is very limited. What I am suggesting, just have a polytechnic college or ITR college in the prison. I am not suggesting have a law college there, at an arts college or chartered accountant course, have several courses. But your scope is very large. A lot of opportunities are available on the part of you. So just one technical something institution ought to be provided inside, because we can utilize their time when they are behind the bar. So we are wasting their energy. We are wasting our time as well, their time as well, maintaining them. So the query to your question is this: so far victims are concerned, probably you can explain to the students that they are having remedy in civil also. If I am assaulted, I am having every right to claim the compensation. Even in case of the murder, now law is developed. The legal heirs of the person who is killed can claim the compensation, can claim the damages from the accuser, and that is the remedy available to them. Now, so far the another part is concerned, that is the offenders are concerned or the culprits are concerned. Now see here, again I repeat the principle of Mahatma Gandhi. We have to cure the criminal. It is not better to kill him. So we are expected to try to reform the criminal, and several criminals are reformed. I found when I had been to Bombay Central Jail, out of 10 lifers, 8 lifers were such who were completely innocent. One of the facts of one of the cases I will tell you. क्रिकेट की मॅच चालू होती आणि जो ज्याला लाईफ इम्प्रिझनमेंट झाली होती तो आरोपी बॅटिंग करत होता, त्याची सेंचुरी झाली तरीही तो आउट होत नव्हता. आणि मग हा इकडला जो बेलफिशर होता फिल्डिंग करणाऱ्या टीमचा, त्यांच्यामधला कुणीतरी एक जण खाली त्या ग्राउंडमध्ये उतरला आणि त्याच्या अंगावर त्यांनी पाणी फेकलं त्या बॅट्समनच्या अंगावर, आणि त्या बॅट्समनला त्याचा एवढा राग आला की त्यांनी ती हातातली क्रिकेटची बॅट घेऊन त्याचा पिच्छा केला, ग्राउंडमध्ये त्याच्या डोक्यात 4 बॅटी मारल्या आणि एक्सपायर्ड. Now see, what is the fault on the part of that fellow? He was just playing the cricket. आता ठीक आहे, who is provoked him, culpable homicide, murder, you might have a thought for that. So in such cases, at least the law must be liberal. In each and every case, if you are keeping, now this person can be reformed very well. And what I said just few minutes to you before you, that you are expected to control your own temperament. Now this fellow has become victim of his own temperament. If he might have controlled for the just 2 minutes, 1 minute, he cannot be a part of victim is a complete different aspect in law. Yes, please.
Criminal. So my question is that while doing that, we do so many amendments to escape from that crime. Like someone is not actually a criminal, and for those people we create some remedies, like you said, sir. We create some remedial laws and all of this. But what happens is whoever accused in the same way, he gets a loophole to escape from that same crime. So what can we do to stop these kind of things?
Yes, I will tell you. Ultimately, again, here the question of skill of lawyer is involved. So, irrespective, my client might have confessed before me in my cabin. I repeat, being a legal advisor, I will look into the charge sheet, I will look into all the papers, and from papers I can assess, I can judge whether exactly, really, whether he has committed the crime or not. Loopholes mean the loopholes which are left by the prosecution. Ultimately, that's why the accused are acquitted. Now, in one sense, those cannot be said to be the loopholes, because the very basic concept in the criminal law is this: the prosecution has to prove the case beyond reasonable doubt, all reasonable doubts. Means here, keeping a loophole means there is a doubt, and if there is a doubt, conviction should not be, because innocent should not be punished. So my friend, if you imagine, if you are convicted for the offense which you are not committed, and if you are sent to the jail for 6 months, I fear when you will come back, you will be the hardened criminal, because you may have the friendship with all inmates in the jail, and those walls and those all things, those police officers, you will feel that it is very easy. As a far awkward nature, we will hit somebody and we will go back and we will create a terror. So the innocent should not be punished. This is the care taken by law. And that's why if acquittals are there in more number, then it doesn't mean that all those are acquitted who have committed the offences. Some amongst them might have committed the offences, but on account of lack of proof on the part of prosecution, they might have been acquitted. And this is based on this principle that it's 100 criminals may be acquitted, but one innocent should not be punished. And that care we have to take. Because nowadays, as I was telling to ma'am, 498 and domestic violence act cases, so a large number misuse is going to be made of that provision. You know, in a very interesting thing I told in one of the lectures, so far domestic violence is concerned, particularly this side will be very interesting to hear this. सासूनं सुनाला टोमणे मारणे, हे तर डोमेस्टिक व्हायलन्स मध्ये येतच. कुठल्याही प्रकारचे टोमणे मारणे, स्वयंपाक is concerned, एखादी सासूच्या म्हणाली मी तुला बोलतच नाही, इट इज ऑल्सो रियालिटी. बोललं पाहिजे आणि गोड बोललं पाहिजे मला. दिस इज anticipation now. So see, the scope is so highly widened in domestic violence. So it is very easy on the part of some of the daughters-in-laws to prosecute. I don't say all cases are false, but some will be misused. I think let's stop here. I have continued for 1 hour. I am expected to stop here.
Thank you, sir.
Okay, fine. Thanks all of you again, and then particularly, oh sorry, you can, as of right, please.
One last question, sir. My question is different from other, that is criminology and all. Sir, what is your opinion about applying the uniform civil code? Because nowadays, lots of crimes are happening just because of regional dispute and all. And sir, can you give us your guidance for how can we start practicing after completing?
Your questions are twofold. Uniform civil code, one thing, and secondly, how can
We start practicing.
on criminal side or civil side you are asking?
Whatever.
Okay. Just so far, first question is concerned, uniform civil code is concerned. I will tell you, uniform civil code is possible in only vegetative cases, that is civil cases. So far, criminal matters are concerned, it is already valid. Even any person belonging to any religion commit the offense, we are having Indian Penal Code, CRPC, all these things are there. And so far, uniform civil code is concerned, I am having certain doubts in my mind. So far, personal laws are concerned, I don't think that the uniform civil code can make successful encroachment on the personal laws. Because just like in Hindu, Saptapadi is concerned, in Mohammedan, Nikah is concerned, Talaq is concerned. So I don't think that personal law provisions may be wiped out and that uniform civil code may be applicable. But so far some common things are concerned, it may be beneficial for all of us definitely. And so far the second query is concerned how to practice. So I will tell the lawyer's office here. It will be very good for you. See here, what is taught in classroom is altogether different and what is in practice is altogether different. examination in the court hall, you will not get an idea that how to put a question, how to cross-examine. So it will be better if you join anybody's office. Just like now, I know Rutuja, she has joined the office of Advocate Tapadia. So she had written to mine, and I requested Mr. Tapadia that she wants to join your office. So she has joined her. So when you will join the court of law, definitely you will get an idea to that difference. So really, if you want to do practice, and that is good practice, it is better to start homework at earliest opportunity. When I will become lawyer, when I will register myself, when my blackboard will be ready after stitching, and then I will start. If that is the idea, then it will be the postponement. And don't postpone the idea. Just try to experience right stage of practice. Definitely, you will not get what you are expecting. Your friend may get 50,000 per month if he has joined any company as engineer, but you will get only 10,000. But don't discourage yourself with this comparison. You should not compare them, because what has happened, I will tell you, what happens ultimately in the life of lawyer when he will leave the practice. One of the lawyers left the practice after doing it for 45 years. 45 वर्ष त्या ग्रस्तांनी प्रॅक्टिस केली आणि नंतर सांगितले की मी आता प्रॅक्टिस सोडतोय. म्हणून त्याचा सत्कार ठेवला बार असोसिएशननी बारमध्ये, आणि त्याचा सत्कार झाल्यानंतर त्याने जे उत्तर दिलं, कदाचित ते उत्तर तुम्हाला खूप महत्त्वाचं ठरेल. तो म्हणाला की मी 45 वर्ष प्रॅक्टिस केली, ते 3 विभागामध्ये आपण विभागूया. पहिले 15 वर्ष मी फक्त काम करत होतो, पैसे मिळत नव्हते. दुसरे 15 वर्ष मी जेवढं काम केलं तेवढे पैसे मिळाले, आणि शेवटच्या 15 वर्षामध्ये काम काहीच केलं नाही, दुसरेच पैसे मिळाले. So ultimately what he suggested, मी जेव्हा माझा ग्राफ काढला वकिलीचा, justice is come to me, and I am in now third phase. It is not the case that I am not doing any work. I am trying my level best, but now I am concentrating because just I that family of 2 daughters. Before percent you will be successful, and definitely I hope you will go to the Supreme Court. Now several students of this college are hypothesis. You might be knowing several students are there. So fortunately, if I got an opportunity to see you in the dais, either on the district court or in the high court or the Supreme Court, I will feel myself very lucky. So wish you again all the best, and thanks to Principal Ma'am and the Shakti sir, because credit goes to him, because one RR is called by another RR. I repeat this because that I got an opportunity. I got an opportunity. Again, sincere thanks. If any error, mistake or grammatical mistake has happened, I'm sorry for that. I confess for that.
Thank you, sir, for your wonderful expertise knowledge. These are the questions that every student, while learning criminology and human rights, do ask our teachers every time when the topic is in session. Thank you so much, sir. Now I request our Professor Unnati Jadhav ma'am to give the vote of thanks.
A very good morning to all who present here. First of all, I would like to thank Shetty sir for arranging this session. So I feel honored and privileged to propose vote of thanks. I, Professor Unnati Jadhav, on behalf of Dayanand Education Society's Dayanand College of Law, I extend my sincere thanks to the chief guest of today's program, R. DESHPANDE sir. Sir, thank you so much for guiding our students, and thank you so much for sharing your experience. सरांनी जसं की आता सांगितलं की फक्त बुकिश जे नॉलेज आहे ते इम्पॉर्टंट नाही आहे, तुम्हाला प्रॅक्टिकली ते अप्लाय करावं लागणार आहे. आणि सरांनी जे सांगितलं की फक्त तुमचा जो क्लायंट आहे, वॉट एव्हर मे बी द सिच्युएशन इज, even though he surrender in front of you, you have to protect his rights, you have to argue in front of court, right? की काही झालं तरी माझ्या क्लायंटला न्याय मिळाला पाहिजे, ती तुमची सुद्धा टेंडन्सी
तुमच्याकडे की तुम्ही सुप्रीम कोर्टामध्ये या. जी एक डिस्टन्स होता फ्रॉम तालुका फ्रॉम द डिस्ट्रिक्ट टू द सुप्रीम कोर्ट, हा जो डिस्टन्स होता ते सरांनी थोडासा रिड्यूस केला आहे आणि त्यांनी तुमच्याकडे एक हात पुढे केला आहे. तर तुम्ही सुद्धा डेफिनेटली sharing with us your experiences. I also would like to thank our principal. He was a guidance to present. Thank you so much for giving this opportunity. You have arranged. Also, I would like to thank our teaching staff and a big thank to our students. ज्यांनी पेशंटली हा प्रोग्राम ऐकला, एवढा छान प्रतिसाद दिला आणि त्याचं श्रेय मी कुठेतरी देशपांडे सरांनाच देऊ इच्छिते. बिकॉज ही वॉज अ लेक्चरर अँड ही नो हाऊ टू होल्ड द स्टुडंट्स. बिकॉज त्यांनी जे एक्झाम्पल्स दिले, जे काही ज्या टर्म्स होत्या, ज्या तुम्ही जर रीड केलात त्या टर्म्स एक वेळेस रीड केल्यानंतर त्या तुम्हाला लक्षात येणारच नाही, राईट. पण त्याच टर्म्स सरांनी एक सुंदर असे एक्झाम्पल्स देऊन प्रॅक्टिकली त्यांच्या समोर जे केसेस आले ते तुमच्यासमोर प्रेझेंट करून तुमचाही जो इंटरेस्ट आहे तो या फील्डमधला जो इंटरेस्ट आहे तो आणखी डेव्हलप केला आहे. आणि तेच मी समजते की आजच्या या प्रोग्रामचे आउटपुट आहे ते खूप सुंदररित्या तुमच्यापर्यंत डिलिव्हर झालं आहे असं मी समजते. थँक्यू सो मच.
I hereby say that this program has been concluded, and on behalf of everyone, I thank our guests and our students and the teaching and